Now available on Tata Sky channel number 526.
Delayed possession, stamp duty, registration, conversion of land or inheritance. If you have any legal query related to property, then you've come to the right place. A very, very warm welcome to you. This is Magicbricks Now. This is India's first property channel and you are watching Property Hotline with me, Kavita Krishnan. Like you might have guessed, we are answering all your legal queries related to property today. Our special guest is Hemang Jariwala. Hemang joins me in the Mumbai studio. He's an advocate at the Bombay High Court. Hemang, welcome to the show. Let's get started with an email query. Subhash Jarodia has written in and he wants to know if it is necessary to obtain a probate of a will. He also wants to know which is a competent court in Delhi to grant a probate and how the court fee is decided for granting the probate. Additionally, he wants to know if a Delhi court can grant probate for a property located in Pune, especially if the beneficiary is residing in Delhi. Now, this almost sounds like one of those bank questions, the home loan questions. Can I take a loan for a house in Pune if I'm living in Delhi?
Correct. No, the first point is that will should be probated, especially when the will is having the immovable properties which are stated therein by the person who has made that will. Because whenever there is immovable properties, you will need a probated will so that the property can be transferred in the name of the beneficiary. Probating of the will means that the will which has been executed by a person who is the owner, and after his death, the properties will devolve upon the legal heirs. So all the legal heirs would be put to notice and only thereafter the will be probated. So there is no dispute thereafter.
So what exactly happens when you probate a will, Hemang? Say I were to will my property to my heirs, do I need to probate it, before, as in when I'm alive, or can my heirs go in for a probate after my death? What does it mean?
Will is a document which is the wishes of the person that after his death, he wants the movables and the immovables properties to be given to persons named therein, maybe legal heirs, maybe third persons. A will can be probated only after the person has expired and not prior to that. So, a will which is prepared with two witnesses and could be registered, could not be registered, but it can be probated only after the person has expired. Once that process is done through a competent court, which is the testamentary department of the original side of the court, could be the district court or could be the high court.
What do you mean by the original side of the court?
The testamentary department deals with all these will issues. Okay, that is will prepared by this individual. It goes to the department. Then the department puts up the notice to all the legal heirs who are connected with this gentleman, and they are called if there is any objection to probating of the will. Probating of the will means an official stamp by the concerned court saying that what is stated therein is not objected by anybody, and the executor is been given the authority to execute and distribute all the movables and immovables as wished by the deceased to the people and the persons named therein.
Okay. Quick question. Do you have to name a separate executor, or can one of the heirs be an executor?
Yes, one of the heirs can be an executor. So, but the will has to have an executor because the onus is on the executor to probate the will and after probating the will to distribute under the supervision of the honorable court whether the distribution has been done completely, and the report has to be submitted to the court that he is complied with the directions.
Subhash also had a very interesting question. He wanted to know if the property is in Pune and is residing in Delhi, can the will be probated in Delhi?
Yes, will can be probated irrespective of the property being anywhere. So, Delhi does have jurisdiction to probate the will.
Okay, so very quickly, let me just wrap up. It was almost like a 101 on inheritance over there. So this is what Hemang had to say. One is, if you have property, ensure you leave behind a will. The will can be probated only after the death of the person concerned. When you write a will, ensure that you not only name the heirs, you also need to name the executor of the will. One of the heirs can be an executor. It is advisable, however, to have an executor who's not either of the heirs. Also, if you have a will, the testamentary department of the court is the one which is responsible to probate the will. So you will have to go to court after the person's death to get that will probated. And yes, you can be living anywhere in the country, so you can probate the will anywhere in the country. Doesn't matter where the property in question is located. Let's move on. We have Mr. Agarwal, who's called in from Gurgaon. Mr. Agarwal, go on. How can we help you?
Yeah, good evening, sir. This is ID Agarwal from Gurgaon.
Yes, Mr. Agarwal, tell us.
Actually, I have one query regarding my booking in, there is a project in Gurgaon, Express Green. I had booked one flat there and in 2009 actually. And the matter is now, the occupancy certificate has been given by the government to the developer. And but the matter is under Supreme Court consideration because the matter is pending under Supreme Court. Some case is pending related to that land and other areas also. But the builder is now offering the possession actually and conveyance deed, execution of the conveyance deed. So my query is, should we go ahead with the, that conditional possession and the execution of conveyance deed? Though the work is under hold right now, and there is no clarity when the work will start. So, as on date, the status is like the flat is non-habitable in that perspective. Though the construction is over, but there are certain facilities which are pending, like sewer line connection and other activities are pending. So, what is I would like to know the legal advice. Should we go ahead with the taking possession, conditional possession, and execution of the conveyance deed?
Mr. Agarwal, just for clarity, when you say that the flat is non-habitable, you are very clear that certain basic utilities are not there. Tell us this, can you walk into that flat? Does it have a roof? Does it have four walls?
This construction is almost completed. Only finishing part is left. That is already 50% of the finishing is already completed. But that the entire towers are completed as such. But non-habitable means the basic, like one is the sewer line which is not connected yet from the government connection, it is pending. And the other small works are pending, though the entire project is on the verge of completion.
Have you got water and electricity?
Water and electricity, as per the builder, it is available. Connection has been given by the government. But I'm not sure what is the actual status on the site.
Hemang, what should he do? Should he accept possession? The builder is giving him both OC and conveyance.
Yeah, one good thing is that OC has already been given to the builder. It means that the certain level of construction and finishing work as per the government is complete. Second important thing is that he is giving you the possession as well as the conveyance. So Mr. Agarwal, my advice to you would be that with OC being granted, please take the possession of the flat, maybe a little 10-20% of the finishing, or as you have said that certain amenities, facilities are still not up to the mark. Take the possession, get the conveyance done, and thereafter as a group, please follow up with the concerned departments and try to get the sewage lines so that the flat will become habitable by you. And if there is still some defects or deficiencies, then you are always open to pursue that matter with the consumer forum once you have taken the possession and the conveyance is done in the favor of the association. So please take possession and get the conveyance done as soon as possible.
So take possession is the answer over here. Moving on, we have another caller on the line. Venkatraman has dialed in from Mumbai. How can we help you, sir?
Sir, I have a flat in Pune. Jointly with my son. I am 86 years old. And my son, who was 52, passed away recently. My son recently died. And my son has left behind his wife and a daughter. Daughter is 22 years of age. I want to know I want to sell the flat now because I'm very old. I don't want to stay alone there. I am thinking of selling it. I have to get clearance from my daughter-in-law and granddaughter. Is it necessary? I should get that clearance because the property was in my name and my son's name. And my son has got wife and daughters. Should they okay for selling? One thing. Hello?
Yes, Mr. Venkatraman, we can hear you. You want to know whether you can sell this property which was in your son's name, right?
Yes. But my son has got a flood in Bombay, Pune. Separately. Secondly, I have to go to the society for changing the relative name of my son's name from the share certificate. My son's name is there, the share certificate. That I got to get it removed from the certificate. What should they do? How should they proceed? How should they proceed in this matter?
Then Mr. Venkatraman, let me get in Hemang. Hemang, how should he proceed to remove his son's name from the share certificate of the flat? And can he sell it once that has been done?
Right. See, in Mr. Raman's case, what is the situation is that it is a joint ownership with him and his son. Son unfortunately has expired, leaving behind the wife and the daughter. Now, if he wants to sell the premises, in normal courts, there can be, if the daughter is also a major, then you can enter into a sale deed with the wife and the daughter, if the daughter is major, as a confirming party, and sell the premises to a third party. This is one way of doing it. Second way of doing it is that the wife and the daughter can relinquish their right by executing a release deed in your favor, so that you will become 100% owner, and then you can sell the flat to a third party. But if the daughter is a minor, then unless and until the courts grant you the permission, you cannot sell her share or create any third party right to her share in this regards. So if the daughter is a minor, then the court's permission is a must.
Right. Mr. Venkatraman, if you're still on the phone line with us, can you tell us if your granddaughter is a minor or a major?
She's a major. She's 22 years old.
She's 23 years old.
Very well. Then I do not see any problem. If you want to sell and if you have a buyer at hand, then please enter into a sale deed with the wife and the daughter as a confirming party and enter into that sale agreement with them.
That will be the easiest thing that he can do.
That is correct. That is the fastest way of going about, so that he will be able to sell the flat and get the money for that premises.
So, Mr. Venkatraman, enter into a joint sale deed with your daughter-in-law and your granddaughter. That is the easiest and simplest route to sell that flat. Next, let's take a question that's coming in on our website, www.mbnow.in. Dilip Moat has written in. He says that he's purchased a flat with a reputed builder in Bengaluru. Now, they sent him the possession intimation letter since they've received the OC. However, they said that registration will be done only when they receive the e-Khata certificate. Now, he wants to know if it is legal to stay in the flat without registering it. Will he be penalized for the delay in registration? Hemang, to this, I want to add a question. Now, how important is that e-Khata certification? Because as far as I know, this is the land title that we're talking about, right?
Correct. Basically, e-Khata is where the title of the land is what is being required by the builder. Builder is waiting for that to come to him. But what is surprising is that the building is constructed, OC has been received, and still the builder has not even taken any steps to enter into an agreement with the flat purchaser. Neither has he bothered to even register the same. But in this case, what I would suggest, since the builder is offering the possession, since the OC has been received, please take the possession of the said flat, take a possession letter from the builder that he is giving you the possession of flat number so and so, so that you will not be considered as a trespasser in the premises. Okay, there would be some sort of permission granted by the builder for your occupation of the said flat, subject to registration of the agreement as that e-Khata comes into effect. So please take the possession with a possession letter and thereafter enter the agreement stamped, duly stamped and registered.
But to safeguard his own rights over here, since it's obviously very clear that A, the builder doesn't have the title certificate for the land, which eventually he has to pass on to the buyer. And that is the reason, Dilip, why he's telling you do not go in for registration. So that is a big problem over here. Now tell us this, should he go and register that possession, once he gets a document giving him possession of the flat, would you suggest he go and register it at least?
Yes, see, agreements basically, a clause could be put in that subject to the e-khata coming in or any other title documents coming in. Subject to that, also agreements can be registered. So there is no issue as to not to go and register a document. Registration of a document under the Transfer of Property Act is the only way a flat purchaser will actually become the owner of the said premises. So subject to this also agreements can be entered into and could be registered.
So Dilip, essentially what you need to be very clear about is that the only legal proof that you have of your ownership over this particular property is the registration that you will be doing for the agreement. Once the agreement is registered, that is the time when you actually have ownership over the property. So like Hemang said, sit down and talk to your builder, draw up an agreement which has a clause saying that you're getting into this subject to the fact that he will pass on the e-khata documents once he gets it, and then go ahead, sign it and register it. That is the best way that you can, best route that you can take, which will also safeguard your rights as a buyer. Atin has dialed in from Pune. Atin, how can I help you?
Yeah. Hello. Hi. Actually, I have around 8,000 square feet of land property in Pune.
Mm-hmm.
And what I want to do is I want to convert it into non-agricultural status. And right now it's an agricultural land. So just I wanted to know what are the procedure and what is the cost involved in doing this conversion.
Hemang, is there any cost involved if you want to convert agricultural land into non-agricultural land?
First, Mr. Yatin, you have to approach the collector, okay, and once you approach the collector, you have to inform him as to why you want to convert an agricultural land into an NA. Secondly, what is important for them is whether the land which is owned by you is being cultivated for the past so many years or not. What is the cultivation presently going on? So if it is an agricultural land and which is a fruitful agricultural land, the possibility of agricultural land being converted by default into non-agricultural land or by due course, it doesn't happen. You have to justify as to why this land needs to be converted into a non-agricultural land. And if the collector, there is a set of documents which you need to give to the collector. So under section 44 of the Maharashtra Land Revenue Act, these all justifications have to be put in before the collector. And if the collector feels that this is a justified cause, then and then only an agricultural land can be converted into an NA.
Right. Atin, one quick question. Where is this land located? Is it in one of those villages which are scheduled to, come within the Pune Municipal Corporation?
No, it's outside the PMC limit. I mean the Pune Municipal Corporation limit. So if I tell you the exact location, it's somewhere near Wagholi. It's somewhere in the outskirts of Wagholi towards Nagar Road.
Towards Nagar Road. No, what I'm asking you is this among those areas which will eventually be absorbed into the Pune Municipal Corporation limits?
They are saying that is the plan, but I don't know when that plan will get executed.
Hemang,
I would suggest that why don't you meet the collector? The collector is the right person to guide you in this subject, because there are certain zonings also which the collector does, even if it doesn't come under the PMC. There are certain zoning areas in which agricultural lands for development purposes are allowed to be converted into non-agriculture. So I think you can just go and meet the collector and take his opinion on the subject, whether your land falls under that zoning area where agricultural and non-agricultural lands are possible.
Hemang, he also wanted to know about the cost. Now, if this is a land that has been identified by the municipal corporation, which they want to bring within the municipal corporation limits, And in that case, will the conversion to NA be free of cost?
No, basically there is no much cost in converting from agricultural to NA, subject to there are some stipulated fees and all that which got to be paid. Otherwise, there is no major cost as such.
Okay, no major cost over there, but the best thing that you could do, Atin, is go and meet with the collector. You'll probably end up having an easier, process of transfer on your hand. With that, let's take Sudhir, who's called in. Sudhir, how can we help you?
Yes, please. Hi, I'm based in Bombay and I've invested in a property in Bangalore.
Okay.
This was actually marketed by Tata. So, a lot of web marketing had happened. So I know buyers who bought from the US, Singapore. So, in fact, the project was, portrayed to be a very big project and, a lot of amenities were supposed to come. So the truth is there is no street lighting also as on date. So I'm not very happy with the project and I wanted to pull out. So I just want to understand if the builder is rightfully claiming forfeiture and if buyers, because I know at least 10 other buyers were unhappy with the project and the progress because there was some APMC supposed to come there which has not yet come, due to which the progress is really slow. So the builder is now demanding forfeiture, which will be practically the entire amount we've paid except for 15% which they're going to return to us. So I would like to know if we can do anything about it because, the marketing was done on the web. Okay, so a lot of people, went through the same problem. So a lot of people didn't visit the site, including me. And we've
Sudhir, how long have you held this property? When did you book?
Since December 2013. So it's already, more than 2.5 years.
When were you promised possession?
Possession was supposed to be last year, so possession has not happened. It is already delayed by 1 year. I've asked them for compensation. They say the compensation check will be calculated after possession and they cannot give any values right now. So is that right?
And what about construction? How far has it progressed? You said there are no street lights even, but what about construction?
Yeah, construction is happening. So phase 1 is almost, done. The structure is ready. So I think it should be handed over in another 3-4 months. And phase 2, they will start. So phase 2, they are saying another 1.5 years. So I've been, fighting on email for a very long time with Tata. And I know many other buyers have fallen in the trap. So now forfeiture, how justified is a builder claiming forfeiture for a project? Because most of the amenities which were promised in and around...
Hemang, this is one of the biggest brands in the country. And they are demanding forfeiture when in fact they were supposed to deliver a project that has been delayed. Basic amenities like street lighting has not been given. What should Sudhir do? Is he liable to pay the forfeiture if he cancels his booking?
So basically, if the builder has defaulted or breached his own timeline, the question of the builder now turning around and asking for a forfeiture or to evoke the forfeiture clause is not justified. Also, please find out whether the Karnataka government has gazetted the RERA Act or not. As Maharashtra already has done on 26th of March, this act has come into play. It has been gazetted also. So, just see whether Karnataka has also taken this act in its true spirit. If that is the case, only what is the issue now is to appointment of the authority. If the authority has been established, then you have a case, directly go and approach, file a complaint, and not only the forfeiture issue will go away, but the RERA Act is absolutely watertight, wherein compensation per month for any delay or deficiency is all in the framework of the Act. If the officer is still not appointed by the Karnataka government, you can file a consumer dispute, stop any such forfeiture by the builder, right, and continue with the consumer complaint till the time an officer is appointed, because RERA permits the conversion of the consumer complaint into a complaint before the officer appointed by the state government under RERA. RERA says that if there is any delay or if the builder has taken more time than required, then the flat purchasers can make a simple complaint to the officer or the authority as appointed, and you would be compensated for every month of delay, and there is no issue of any forfeiture at all, because the registration would be revoked and stringent action will be taken against the builder.
Right. In fact, you don't have to pay the developer anything over here. You can ask the developer to compensate you, and that is your right. And that is something that even the consumer courts will grant you. So if RERA has been gazetted, like Hemang said, ensure that you file the case under RERA. If not, go to the consumer court. Also, Hemang, he said that there are other buyers involved. They all bought this online very quickly. Do you think that they should group together? We are running out of time here.
Yeah, class action is always advisable in such cases. A class action not only before the consumer forum, but as I've always said, also a class action against the, take it up with the economic offense wing also. That you people have been given a rosy picture, lot of money has been taken by these developers, and today nothing is happening in reality, and that is how you have been cheated by them.
Right, so just take all possible action against them. Don't just stop at one avenue. There are many routes that you can follow. File a class action suit, go to the consumer forum, go to the economic offences wing, and if RERA has been notified, then go and file a case under RERA as well. That's all the time we have on today's episode of Property Hotline. Thank you very much, Hemang Jariwala, for coming in. If you have any queries related to real estate, whether it is legal queries like these, or it is about investing, buying or selling property, tax queries or even home finance, you can reach us on the IDs that are flashing on your screens. We'll get the country's top experts to answer them. That's a promise. You can also personally tweet to me. Stay tuned to Magicbricks Now.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.